Earlier this week, we told you about a new development in the Curtis Flowers case.
4 black voters and a branch of the NAACP are suing Mississippi prosecutor Doug Evans. The lawsuit claims Evans excludes black people from sitting on juries at a rate that's not equal to that of whites. Evans has tried Curtis Flowers 6 times for the alleged killing of 4 people in a Winona furniture store back in the 90s. The Supreme Court overturned Flowers' conviction, finding racial bias in the jury selection. And joining us now is attorney Raymond Fraser. He's here to shed a bit of knowledge on court proceedings and why jury selection is so important. Thank you so much for coming on.
Good afternoon. Thank you for having me.
Thank you. Shed some light on this. Kind of go through this. How are juries selected?
Well, in a criminal trial in Mississippi, the verdict of the jury must be unanimous.
Okay.
And 12 jurors are necessary for a verdict in circuit court. Selection and paneling of the jury is strictly a judicial function, and the circuit judge has an absolute duty to see that the jury selected in any case is fair, impartial, and competent. Now, ratified in 1868 in the wake of the Civil War, the 14th Amendment to the Constitution requires equal protection under the laws of the United States for all citizens, regardless of their race. It is Mississippi law that a citizen shall not be excluded from jury service in this state on the account of race, color, religion, sex, national origin, or economic status. Now, in this situation, in a criminal trial, we have the prosecutor who represents the state and the defense attorney that represents the accused. Now, the process for selecting a jury is called voir dire. The purpose is to select a fair and impartial jury, of course. And challenges to potential jurors may be made for cause where there is reasonable grounds to believe that the jury cannot render a fair or impartial verdict, or peremptory. And a peremptory challenge may not be based on any good reason. It just cannot have a racial discriminatory purpose.
Okay, it's just other than the person making the objection just has an objection.
That's correct.
Okay.
Who might be the reasonable juror?
A reasonable juror is anyone able to serve that does not have a challenge for cause or peremptory challenge from one of the attorneys.
Yeah.
Now, Supreme Court sets out in case law exhaustive lists of race-neutral reasons for peremptory challenges.
Okay. So in other words, a person can be excluded, and they can be of any race, and it doesn't necessarily have to be about race.
That's correct.
Okay. But I guess in this particular case, the challenge is being made because evidently someone suspects that these jurors have been excused because of race. I think I'm getting that right.
Certainly so.
Yeah. Okay.
In the 6 trials combined, the state uses peremptory challenges to strike 41 of the 42 prospective black jurors in its efforts to ensure that Flowers faced an all-white jury.
Wow. Okay. What is the job of the prosecutor?
Well, the prosecutor carries the burden of the state to prove that the defendant or the accused has violated whichever statute is in play.
Okay, and then the defense attorney is the one there saying, no, he didn't.
Correct. The defense attorney protects the accused.
And at this point, they're not still looking for someone. They're both under the impression that this is, the prosecutors say, well, this is the person that did it. And the defense attorney is saying, no, this person didn't do it. And so it's not like they're still looking for truth in the case. They're looking to prosecute this person or defend this person. Is that right?
Correct. But this case is on an appeal due to the procedural aspects of the case. Okay. The discriminatory acts in this jury selection process. Now, the Supreme Court has held that the 6th Amendment requires that a jury be drawn from a fair cross-section of the community where a crime has been committed. Yeah. In Batson v. Kentucky, which is a very important case to jury selection, the Supreme Court specifically ruled that a state denies a black defendant equal protection when it puts him on trial before a jury from which members of his race have been purposely excluded.
Okay. Well, I'm assuming then, obviously, that we all are going to be following this, but you particularly in the law profession will be following it very closely to see how this comes out.
We certainly will. And I will leave you with the proposition that equal justice under the law requires a criminal trial free of discrimination in the jury selection process.
I think everybody would agree with that.
Yeah, absolutely. We'll keep an eye on this. Thank you again for coming on.
All right, thank you for having me.